Okay, so good morning and welcome to today's webinar. It is called Eviction, Disability, and COVID-19 Know Your Rights. Good morning, my name is Francisca Beltran. I am the Community Outreach Coordinator for the Lincoln Commission on Human Rights for the City of Lincoln. The Lincoln Commission on Human Rights, or LCHR, is responsible for preventing and responding to all forms of discrimination in the City of Lincoln. We also work to assure and foster equal opportunity to all of our citizens of the City of Lincoln. So many community members who are facing eviction, often for the first time now as a result of COVID-19 crisis, live with underlying disabilities that make forced displacement extremely dangerous during the COVID-19 pandemic. Many agencies are working to support community members and keep families housed during the pandemic. Our webinar today brings the following organizations together today to provide information about disability and housing rights during the pandemic. Disability Rights Nebraska, the Tenant Assistant Project, Nebraska Equal Opportunity Commission, the Lincoln Commission on Human Rights, and the Fair Housing Center of Nebraska and Iowa. We hope to provide information and dispel any misconceptions about disabilities and the eviction process, particularly what we have been seeing at the Lancaster County, as well as cover rights tenants with disabilities have under the Fair Housing Act, including how to ask for reasonable accommodations that are needed as a result of the pandemic. And most importantly, we hope to provide contact information for community members that can utilize to reach out for more information and assistance now or in the future. So welcome, we're excited to have you join us today. We have a great program ahead of us and a lot of information. Remember, this is being recorded. We will have a link to this information and we will also take any questions throughout in our Facebook Live. They will be fed to us and I will read them out. Please, if you have any comments, we would love to hear from you during this time. There's a wealth of information, so thank you for joining us today. Today, first off, is our speaker, Brad Murrens, who is the Public Policy Director of Disability Rights Nebraska. I want to thank Brad and the rest of our organizations that are with us today. Throughout this program, I will be emceeing, so thank you again. And Brad, we will start with our PowerPoint. If you have any questions for him as he is currently presenting, we will go from there. Thank you so much, and Brad, welcome this morning.
Well, thank you. Thank you very much. I appreciate the opportunity to speak on this important issue, and it's growing more and more in importance day by day. But just Disability Rights Nebraska, just to kind of give you a sense of who we are and what we do. We are the designated protection and advocacy organization for persons with disabilities in Nebraska. And basically our main charge is to advocate and to protect the rights of persons with disabilities here in Nebraska and to support them. Our vision is that Nebraskans with disabilities, especially those who are most vulnerable, will be free from harm and able to exercise the same rights, opportunities, and choices that folks in our communities that don't have disabilities can, that they freely enjoy. And we have identified three particular areas of service up until for this last 5-year strategic plan. And those three areas are working to keep people with disabilities free from harm and neglect and abuse. We are working to keep people with disabilities to have the most inclusive, to be living in the most inclusive settings and to gain the most from living in the community. And our third priority is engaging people with disabilities directly in advocacy to support them testifying in front of the legislature or helping to develop advocacy skills that they can use in other areas of their lives. We're interested in that. And now, granted, those are pretty wide-ranging topics, and a lot of issues fall within those categories. So we always say, if you have an issue, give us a call and let's figure out what we can do if we do anything about it. Next slide. So my role here is to kind of give you a little bit of a context and to put a little bit of a framework on this evictions issue and to provide the disability sort of framework and context for the issue of evictions. And one of the main things that we commit to in our organization is the realization that disability is a natural part of the human experience. And it does not diminish the rights of individuals to enjoy the opportunities to live independently, to live their lives, to be a contributing member of society, and to experience full integration and inclusion in their society and in their communities. And we have to also remember that about 11 to 20% of our population in Nebraska and in the country in general identifies as having a type of disability. So we're talking about a substantial amount of folks that live in our communities, in our neighborhoods, and in our state and in our country. Next slide. So what is a disability? Well, that's a very good question. A disability is any condition of the body or mind that makes it more difficult for the person with the condition to do certain activities and interact with the world. It's a pretty broad definition. To get a little bit more particular, I've included in the red box on your screen the actual federal definition of disability that is contained within the Americans with Disabilities Act. And you'll notice again in this federal definition, it's pretty broad. But again, we're talking about a very broad spectrum of disability types and a very broad spectrum of individuals who will have one of those impediments. So look, and extending upon that, if you look on the left-hand side in the bullets there's a list of a variety of disability types that might be accrued by an individual. So they could have a difficulty or an impairment with their vision or their movement, remembering, learning, communicating, or mental health. Those are just, again, a wide swath of areas that can have a disabling condition. That's why we need to have a very broad definition of disability. Next slide, please. Because disability has a broad spectrum, some disabilities may be what we call hidden or invisible, or maybe not easy to identify. Some of those hidden disabilities might be autism, a brain injury, multiple sclerosis, or even a psychiatric disability. And again, we're talking about a wide-ranging, varied myriad of impairments and a lot of different sort of sensory and movement issues so we need to have a broad range of definition and take a very holistic scope. And disability respects no boundaries, status, or time. Disability is ubiquitous. It affects people of all types of backgrounds, ages, ethnicities, socioeconomic status, etc. Disability does not matter how young or how old, how rich, how much money you have in the bank, how pretty you are, how popular you are. It doesn't matter. Disability can affect you regardless of your background. And disability can be acquired at any time by anyone. We all live on the edge of developing some sort of disability. It's been said that if you live long enough, it is very likely that you will acquire a disabling condition at some point. I think my parents are a great example. They were very healthy, 40, 50-year-olds. And then when later on toward the end, they became full-time wheelchair users. Wasn't their choice. It just was something that happened when their health conditions started to come up, disabling conditions started to pop up as well. Next one. One of the things that people might not think about in terms of disability is that living with a disability is expensive. Some estimate additional annual costs per family with children with disabilities at about $10,000 or $11,000. That's including direct monetary costs, i.e. buying equipment, buying specialized gadgets or food, or it incorporates their indirect costs, things like taking time off work or leaving a job to do more caregiving. Thus, many people or families with disabilities have little to no financial cushion to absorb unexpected expenses. And I think that's one of the key things that would take away from this part of the presentation is that, we're talking about folks that have little to no cushion. So increased deposits, rents, those sort of things will be detrimental to them more than for folks that may not be in that situation. Next slide, please. And disability is individualized and misperceived. Although people with disabilities, that term sometimes refers to a single community. And we talk about the disability community, right? People with disabilities are a diverse group of people with a wide range of individualized needs. And again, I think that reflects back on the first couple of slides when we talked about there's a broad range of disabilities and a broad range of individuals. Two people with the same type of disability can be affected in very different ways. And that having a disability does not mean that you are unhealthy or that you are sick. But often people with disabilities have medical or social, community, or economic conditions that leave them more vulnerable to the coronavirus and also leaves them open to it being more lethal when they do contract the coronavirus for persons with disabilities, for those without disabilities. So I think, again, we need to really think about the disability perspective in the context of coronavirus. And since living with a disability is expensive and people with disabilities live in the margins most of the time, living with a disability often means living in poverty. And the statistics, I think, bear this out pretty well. In Nebraska, according to the American Community Survey, which is a part of the census, Nebraskans 21 to 64 years old with a disability living below the poverty line, 27.8%. Those individuals in Nebraska, same age, without a disability, 8.6. So we see in the data in 2018 that there's almost a 3 to 4 times prevalence rate of poverty for persons with disabilities than those without, even here in Nebraska. People with disabilities are more likely to experience what they call long-term poverty. That is being impoverished or in poverty for over 1 year. And that limited employment opportunities, disability-related barriers to employment, and reduced work history help to sustain this impoverishment. And it can end up being intergenerational. Next slide. And the other implication of living in poverty is that poverty limits your housing options, and disability limits those options even further. Again, poverty, makes the ability of an individual with a disability compromised. Their ability to make new rental deposits or other new housing expenses. That if they get evicted, they got to find another place to live, or they have to get somewhere. They may not have the requisite resources to do that. And or accessible housing may be required for some people, but not all housing is accessible. And especially, I would contend, a lot of the housing that persons who are living in poverty would be able to afford. Next slide. In addition to poverty, people with disabilities face and endure stigma and discrimination, and it still persists to this day. Which also then, the implication is it reduces even further housing options. The Housing and Urban Development reported in 2017 that people with disabilities were still discriminated against in housing. They were less likely to receive a response to their housing inquiry. They were less likely to be told an advertised unit was available. They were less likely to be invited to contact the housing provider or to inspect the available unit. And they may be encouraged to look at a different unit than the one advertised. So again, when you're talking about evictions and housing, and then you add on the disability perspective to it, there are a lot of forces that ratchet down the options and availability for persons with disabilities, which then puts them in an even stronger and worse bind when things do go south or to go sideways due to the COVID-19 virus and it affecting them. Next slide, please. And I think that kind of leads me to my last point, and that is housing is key to flattening the curve. Evicting people in the middle of a pandemic puts them at greater risk of contracting and spreading COVID-19. And I think, and let's not forget the first couple of slides, people with disabilities are more susceptible to contracting the illness, and they are it's more likely to be lethal to them because of their underlying medical conditions and the conditions in which they live a day-to-day in their community. You know, Solomon Green, I think, had a really good quote. He talks about how exposure risk is so much more amplified and worsened when you can't shelter in place because you don't have a place to shelter. So again, I think when we're talking about and considering and thinking about the evictions issue, we need to also be considering in those discussions and in our deliberations the disability perspective. And I think we wanted to bring the disability perspective and the conditions that those individuals deal with to light, so that we can have a more informed discussion and a more educated response to dealing with this particular issue. Thank you.
Great. Thank you so much, Brad. We certainly appreciate the insight and kind of educating us on the fact that, you know, disabilities, it's also a natural part of the human experience, which is very important for all of us to know. We would like to show you a quick video about what the hallway looks like in the justice, in the courtrooms. Yeah. And that's just to give you an idea of what that looks like currently. It is to give us an idea that the people, especially with COVID, not a lot of people are attending, but those that are being evicted are being forced to attend. Okay, so, you know, if you haven't been in there, this is what that looks like. So next, we have Marna Munn, who is the director of the Nebraska Equal Opportunity Commission and brings a wealth of information as to what her agency does. Thank you, Marna, for joining us today, and go ahead and go.
Thank you. And if we could go back one slide, we could start there. Thank you. Thank you, Francisca. I'm happy to participate in the event and help inform Nebraskans of their rights and options during these challenging times. As Francisca said, my name is Marna Munn. I'm an attorney and the executive director of the Nebraska Equal Opportunity Commission, or the NEOC. Our agency is one of 3 organizations in the state that is authorized to help enforce some specific civil rights legislation on the state level, including investigating allegations of discrimination in employment, public accommodation, and housing, which brings us here today. The 3 agencies, as you can see from the screen, include the Nebraska Equal Opportunity Commission. We are a state agency, and our jurisdiction extends across the entire state. And then we also have the Lincoln Commission on Human Rights. They also enforce these civil rights laws in the city of Lincoln. And then we also have the Omaha Human Rights and Relations Department, and they also investigate and enforce these civil rights laws within the city of Omaha. So as I speak today, if you have a Fair Housing Act claim potentially, and you live in the city of Lincoln, you can contact either LCHR or NEOC. And if you live in the city of Omaha, you could contact OHHRD or NEOC. And each of us, for the housing purposes, as we focus in on housing, are considered something called a FAP, which is part of the Fair Housing Assistance Program administered through the United States Housing and Urban Development Department, or HUD. And HUD provides funding annually on a non-competitive basis to state and local agencies to enforce fair housing laws that are substantially equivalent to the Fair Housing Act on the federal level. And so all 3 of the agencies I've just spoken about, including our agency, are all able to do that. And before I move forward, I would note, and I will note it again before I'm done, none of our agencies charge anything to help look into any allegations of discrimination you may have, and you're not required to have an attorney to work through our process. But what we do is that we enforce anti-discrimination laws, And we provide education and outreach to communities on the front end, and also training if it's found that folks have engaged in discrimination. And we do try to provide a technical assistance to the public if you just have a question about these issues. And so next slide, please. What I want to talk about just a little bit is investigating discrimination, so that you have a sense of, if you contact us, you know what that looks like. So we enforce the Fair Housing Act laws, which means that if you believe you've been discriminated against on a protected basis, including race, color, national origin, religion, sex, familial status, the reason we're here today, disability, and then if you've been retaliated against for trying to exercise your right to have an investigation into allegations of discrimination, there can be a claim for retaliation. And so if you contact one of our offices, you're going to talk to an intake individual, an investigator who's trained in these matters, and they're going to be able to help you walk through what your situation is that you're facing with regard to your housing issue, and try to help identify any issues that fall within the anti-discrimination laws, and then help create a charge or a complaint to move the kick off the investigation and move the investigation forward. And so we try to provide an investigator with that expertise, as I said earlier, so that you're not reliant. If you can't afford an attorney, you can work through our process, and we will assist you in getting the complaint or the charge started. After that, we are by law required to conduct a neutral investigation into the allegations. So we send the charge to the respondent, which is the housing provider, either your current landlord that you have an issue with, or perhaps there's been a failure to rent. I will talk about some of those causes of action in a minute. But the housing provider would get a chance to respond to the allegations in the complaint, usually in a written form. And then that information gets sent back to the investigator on the case. The investigator will go through that information. They will talk with you again about what the response was from the housing provider, and then determine whether and what further investigation needs to be done to determine whether there was in fact illegal discrimination under the laws. And so after that analysis, the commission would issue a determination. In our case, our commissioners convene typically once a month, and they would take on the housing cases and determine whether there was reasonable cause to believe that discrimination had occurred in your case, or there was no reasonable cause to determine that illegal discrimination had occurred. A note about finding that there was no reasonable cause, that doesn't mean that you weren't treated unfairly. It doesn't mean that what happened was right. But the laws dictate what rises to the level of whether it's illegal discrimination. And our commissioners are educated in that and well-versed, as are investigators and the unit directors throughout the agency. But should we find that there was reasonable cause to believe that you were discriminated against, the commission would issue that determination. And then from there would be a couple of things that could happen. We have individuals trained in conciliation and settlement that can help essentially mediate the situation for you. Or if that fails, then we could move to public hearing and have an administrative hearing where a hearing officer would review all of the evidence, make a determination, and from there we could determine what the damages and the settlement would be from there. The other option does exist to go into court on the Fair Housing Act issues. And you could do that without using one of our agencies. It's just that, again, because we can move faster than most court cases can in this kind of area of law, and because it doesn't cost anything to use our services, there are reasons to work through our agencies. But you can go into court either during, before, during, or even after we've found cause, and could work through this whole situation in a court as well. So that option remains open. Next slide, please. So now that I've talked a little bit about what our agency does and a little bit about what the process looks like when you work through that process with our agency or through LCHR or OHHRD, I'm going to talk just briefly about the intersection of eviction, fair housing, and disability to kind of bring home the topic that brings us here together today. So in Brad's presentation, he talked about the statistics that show that a person with a disability is less likely to receive a response, less likely to be shown an advertised apartment, less likely to be allowed to inspect, and more likely to be encouraged to find a different or alternate housing. Any and each of those could be causes of action that could be explored under the Fair Housing Act. Essentially, that's a failure to rent, the second bullet point here, or to deny or make housing unavailable. And if they're doing it on the basis of a person who has a disability, then that could possibly rise to the level of illegal discrimination under the Fair Housing Act. And so again, that would be the kind of allegation of discrimination the Nebraska Equal Opportunity Commission or the Lincoln Commission on Human Rights or the Omaha Human Rights and Relations Department could investigate on your behalf if you felt that was happening. In particular, in relation to the COVID-19 situation, evictions, could happen. We do see that there are, clearly the circumstances in the world right now put a lot of people in different positions than they were just a few short months ago. Later in the presentation, I know you're going to hear a lot more about eviction as it relates to landlord-tenant acts. Evictions as it relates to the Fair Housing Act, and I should note that both laws are available to individuals potentially who face eviction or other issues with housing. There may be a cause of action under the Landlord-Tenant Act, and then there may be a cause of action for discrimination under the Fair Housing Act, and claims could be maintained on both under both laws. But if you're being evicted on the basis that you're disabled, or if they're evicting people, but the people that are being evicted are only people with disabilities, and they're either not evicting or allowing different terms and conditions for somebody who's not disabled, that could be a cause of action under the Fair Housing Act, because they would be treating somebody or a group of people who were disabled differently than individuals who are not disabled. If there's harassment on the basis of disability or any indication or suggestion that because of the disability, you're making it difficult on the landlord in some way, or they're giving you grief trying to get to you to leave voluntarily rather than evict you, there's potentially a cause of action. The most likely one in relation to COVID-19 is probably what we would call a reasonable accommodations claim. And again, later you're going to hear good information from the Fair Housing Center of Nebraska and Iowa about reasonable accommodations. But I would just note that that is a cause of action under the Fair Housing Act. If you seek a reasonable accommodation, just in general, or associated with the COVID-19 situation, for example, you are immunocompromised, you have a hidden disability, as Brad discussed earlier, and because of that, you aren't comfortable being able to go into your workspace because you're more vulnerable to contract COVID-19, and so therefore your salary is diminished, and you seek to work with a landlord and they won't speak with you about it or try to work with you, you may have a cause of action where you've sought a reasonable accommodation. And there are several other reasonable accommodation situations that could come up in relation to the COVID-19 situation. And then, as I noted, under the protected bases, the retaliation would be a situation where you did come to one of our agencies and you sought to try to determine or start an investigation into allegations of discrimination. If you were to be evicted then, in part because you exercised the right that you legally have, that could be a retaliation claim that could be added to your complaint. So I just wanted to take a few minutes and go through and explain that there are agencies and organizations specifically dedicated to help in these areas, particularly on the I'm speaking particularly on the Fair Housing Act enforcement, that there are likely situations where there would be an intersection between eviction, but also other causes of action under the Fair Housing Act, where one of our agencies may be able to work with you and walk through that and investigate actions that may have been taken because of your disability or any other protected bases under the law. And we would encourage you, if you have any questions or believe that you have faced or are facing one of these situations, to be in contact with the Nebraska Equal Opportunity Commission or Lincoln Commission on Human Rights or the Omaha Human Rights and Relations Department. Thank you.
Thank you so much, Marna. That was awesome. So I'm going to prompt Bo to show us the next video, which will have somebody who is talking about the experience, a brief experience through the eviction process. Bo?
My name is Vincent Brooks. I had a eviction notice and I won because it wasn't my fault about the traffic, wasn't my fault about paying my rent. So I was thankful that today that I have a second chance. And my name is Vincent.
Thank you. And thank you, Marna, for giving us that great information that we all need to know and know about the resource that the Nebraska Equal Opportunity Commission has. So next we have Laura Hairdale, and she's from the State Bar Association, pardon me. And she'll be giving us great information about the Tenant Assistance Project. So welcome, Lori.
Thank you very much, Francesca. So as she noted, my name is Lori Hairdale. I am an attorney. I'm the director of the Nebraska State Bar Association's Volunteer Lawyer Project. And just a little bit about me, prior to coming to the Bar Association a couple of years ago, I was an attorney at Legal Aid of Nebraska for approximately 17 years, where I worked overseeing access to services. And I also worked a great deal with folks who have disabilities. So I am going to talk a little bit about the Tenant Assistance Program, really how it started and some of the stuff that we're seeing through there. But I just wanted to note as well that you do have a wonderful slide up in front of you with some great information on it, some of which I'll be going over here in just a moment. So please take a moment to look at the information on that slide. Just know that I'm not going to read it to you as I'm working through my presentation, because I want to give you a little more information about what the Tenant Assistance Project is and what it's doing. So essentially a little bit about the Volunteer Lawyers Project, though. We really work to expand access to justice for low-income people who really have no other options, no way to pay a lawyer. And we do that through the use of volunteer attorneys across the state. And so these attorneys give freely of their time to assist low-income people. And today, for this presentation, we're going to focus on what's going on here in Lincoln, in Lancaster County, with respect to evictions and the Tenant Assistance Project. So the goals really of the Tenant Assistance Project are to, the project started really as a result of the pandemic, even though there was a reason for it to be in place prior to the pandemic. And really it's there to assist these low-income tenants. We have attorneys who are giving legal advice, direct legal representation in court. And really the plan is to lower the number of people being evicted in Lancaster County, particularly through the pandemic. And so you've already heard some great information from Marna and from Bradley about what happens when folks are being evicted and really are victims of discrimination, and how the pandemic is affecting folks with disabilities in particular. And so the goal really is to keep people housed, particularly during the pandemic. But this project is going to continue, or at least we hope it will anyway, post-pandemic. So the project started really in March. It was a grassroots effort. We had a few volunteer attorneys who were visiting the Lancaster County courthouse and seeing what was going on in there with respect to evictions. So you may have learned that earlier this year, as a result of the pandemic, the governor had issued an executive order basically halting eviction proceedings during at least the earlier parts of this pandemic. It's certainly stretched on further than what I think we hoped it would. But just so you know, that executive order has ended. And so there's no more halting of evictions except for certain circumstances. So certain tenants living in certain properties are still protected under what's called the CARES Act from being evicted, but that CARES Act expires July 25th. And so we think post July 25th, even those folks who were afforded those additional protections will no longer be protected or will no longer have those defenses. But really, the plan is to keep folks housed, to shelter in place. And as Bradley mentioned, this is absolutely critical during this pandemic. The virus, this virus is very scary and it affects folks with disabilities even more so. They're more apt to get it. And if they do get it, they're more apt to suffer greater consequences as a result. So we want to keep people housed, okay? I would say, well, given my experience through the TAP project, more than 50% of the people we are working with either have the tenant or another occupant in the household who has a disability. So that's the majority of people we're coming into contact with in Lancaster County who are attending eviction hearings have either a disability or somebody in the house with an underlying disability or medical condition. So that's significant. And in fact, I wanted to raise an example we had just yesterday. We had an elderly gentleman, so an older gentleman who was also disabled, being evicted. Really, we couldn't understand the reason for eviction. He was not behind in rent. He hadn't violated his lease, but nonetheless, the landlord had decided they wanted to terminate the lease, really just kind of out of nowhere. And so we were trying to kind of get to the root of this because we were wanting to work with the landlord attorney to try to negotiate for more time for this elderly gentleman whose brother happened to be with him. And his brother was really kind of helping him through this process. But his brother said to us, you know, we have no problems eventually moving his brother, but we can't do it quickly. He is disabled, he has medical conditions, and we don't have a place for him to go. We need to try to get more time. And so ultimately, thankfully, the attorney working directly, the volunteer attorney working directly with the landlord's attorney was able to secure additional time. But some of the information we heard exchanged in the hallway between the landlord and the landlord's attorney really kind of piqued our interest. It really sounded to us like there was some potential discrimination occurring, that they really didn't want to continue to rent to this gentleman because he was on a fixed income. They wanted to raise the rent, and they expected him to seek accommodations for his disabilities, and they didn't feel like they could do that. And so there were some significant concerns there, and I'm going to talk about that as I work through the process that we use through the Tenant Assistance Project when we're working with these low-income tenants who not only need help with the eviction, but who also probably need help with a discrimination case or discrimination claim. So a little bit more about the project. Again, it was grassroots. It started really with 2 volunteer attorneys. Those folks had contacted me at the Volunteer Lawyers Project and asked if we would be willing to assist them by essentially helping kind of create a more formalized project. And so really through our work, we are able to kind of create this formal legal clinic, which is what really the Tenant Assistance Project is. It's a legal clinic occurring inside of the courthouse. And we're able to provide some protections to volunteer attorneys who want to do that work that they wouldn't otherwise get if they weren't doing this work through the Volunteer Lawyers Project. So that's really my piece in this, to provide some formalities and to provide some protections to the volunteer attorneys who want to do this work. I should also note that in addition to the volunteers that we have, there's really a whole kind of coalition that's been built around the Tenant Assistance Project. And that coalition includes legal service providers, and it also includes community organizations who do a lot of the other advocacy work that we as the lawyers aren't engaging in. So having both pieces of the puzzle there is incredibly critical to this project and to the success of it. I should note, even though it started with 2 volunteers, we are now over 60 volunteers, 40 of which are attorneys. So we've had a fantastic turnout of attorneys here in Lincoln and the Lancaster County area who really want to see low-income tenants remain housed, particularly during this time. So how this really works here in Lancaster County is eviction hearings are held 4 days a week, Monday, Tuesday, Wednesday, and Thursday. They start at 8:30 a.m. and then hearings can also occur at 9:30 a.m. or 10:30 a.m. Or you can have a combination of, any morning we could have all the hearings happening all 3 hours. It's what is called cattle call. And what that means is, on any given day, we may have 10 or 15 eviction hearings scheduled at 8:30 a.m. And so all of these tenants, plus the landlords, plus attorneys, are expected to show up at the courthouse. Now, you saw moments ago a video of a fairly narrow hallway that most all of these people who are showing up are gathering in this hallway outside of the courtroom to negotiate and try to figure out a solution if, and hopefully if eviction isn't going to be the solution, hopefully we can negotiate something. But all of this activity occurs outside in that hallway. And so during the pandemic, social distancing can really be a challenge when you've got that many people at the courthouse at one time. Cattle call is meant to be fast paced. So generally speaking, attorneys go into the courtroom, they tell the judge that they're ready to go, and the judge can start promptly at 8:30. Now, landlord attorneys should be checking in the hallways to make sure that they're not overlooking tenants who are appearing. But that is the one nice thing about the Tenant Assistance Project. We are using community volunteers to greet folks as they're coming off of the elevator on the second floor to determine if they're there for an eviction hearing. If they are, and we've identified them as a tenant, we of course talk with them, try to figure out if they're represented. 99.9% of the time they're not represented. We tell them about our project and get their permission then to have a volunteer attorney work with them, and then they give us some basic information and we get started. But community volunteers can do a variety of things. They not only greet people off the elevators, but they can help do intake. They distribute information about the Tenant Assistance Project. One of the things they're working on right now are flyers and what we'll call as door hangers to provide folks who are living in low-income housing or folks who are about to be evicted information about the project and a hotline to call. And so at the bottom of your screen, you're going to see Legal Aid has a hotline for coronavirus-related questions. That is the hotline. Low-income tenants should be calling if they're receiving any notices about eviction, or even prior to that, if they know they can't pay their rent and they're struggling to get by. Okay. So community volunteers also help observe hearings. They also, and I think the big piece here is they work with these tenants to identify whether they have a disability or an underlying medical condition that makes eviction more problematic for them. And like I said, at this point, more than 50% of the people we're working with have either a disability or an underlying medical condition. So once we've determined that, then the community volunteer works with them to help them fill out a request for reasonable accommodation and then the questionnaire. And so that piece is critical. Without the help of community volunteers doing that work, that step would be overlooked. And so we're incredibly grateful for that. They also will get on the phone and help make phone calls to organizations that might be able to provide rental assistance or alternative housing. So community volunteers do a lot of great work. And I think later in the presentation, we have a spot we will provide contact information to who to get a hold of if you're interested in volunteering and being a community volunteer. I also want to stress the work of the volunteer attorneys. They are meeting with these tenants one-on-one, determining what the situation looks like, what really the tenant needs. They're giving them advice, they're negotiating with landlord attorneys, and if necessary, they'll directly represent them in court. Now, direct representation often means that we're going to have a contested hearing or a trial. And I will say that those are by and large not typical. Right at this point, I'd say we're having about 1 to 2 contested hearings or trials per week. So a very small number. The majority of cases are going to get negotiated for more time, or for the ability for more time to move, or for the ability for the tenant to have more time to get caught up on their rent. Volunteer attorneys will also appeal cases if necessary. Those are going to be few and far between. You've got to have the right set of facts. You've got to have the right client, and appeals are very expensive as well. And so those are pretty rare, but we do have one appeal pending at this time. Now, just a little bit of information, kind of some stats to look at. At this point, every single tenant that has appeared for an eviction hearing since May, I will say, has had the opportunity to have a volunteer attorney work with them. So we've had great success in Lancaster County having enough volunteer attorneys to pair up with the tenants. Very few evictions have occurred so far, and so we'll get into that. This project has represented over 75 low-income tenants so far. There's about an 85% success rate in these cases. So, fewer than 20%, actually, I would say fewer than 10% of the folks we've worked with so far have been evicted. So that's fantastic news. That number was much higher prior to the tenant assistance project. In fact, the majority of tenants were being evicted, even if they did show up. So one thing that's critical to note is that right now, less than 50% of the tenants who are being summoned to court are actually showing up. And that can be devastating, because if they don't show up and the landlord, attorney and landlord are there, the landlord is going to get a judgment for restitution of the premises or an eviction, and a writ is going to get filed, and the person is going to be removed from the property if they haven't already moved. And as folks know, having an eviction on your record is just incredibly damaging. It makes it very difficult, if not impossible, to rent in the future. And if it's a low-income person who needs subsidized housing or housing benefits, it's about impossible to get housing benefits or subsidized housing for at least 3 years post that eviction. So it can be incredibly damaging and devastating for these folks. I do want to note, essentially, with respect to the work that's being done through this project, I think it's critical to understand that the majority of cases coming in right now have some form of defect, whether that be on the pleading or a substantive defect. And that's how these attorneys, volunteer attorneys, are able to actually successfully negotiate and get some great outcomes for these tenants. I did talk just a few moments ago about writs being filed. So the process here, and it's not necessarily laid out on your screen, but let me talk you through the eviction process. Essentially, once an eviction occurs, the landlord can then file what's called a writ. And the writ is the direction to either the sheriff or the constable to go to the property and physically remove the tenant from the property, okay? Now, once that writ is filed, the sheriff or constable has 10 days to come out and put the tenant out. So there's not a lot of time. So it can be just absolutely devastating to have an eviction on the record, not only because it's on the record and makes it difficult for you to rent, but because you're going to be put out. And as most folks know, trying to move out of a house, an apartment, whatever, within 10 days or less is very, very difficult to do. And it's even more difficult for somebody who is disabled or has an underlying health condition. Okay, so the one thing I do want to stress is for folks that are working with low-income tenants who are struggling and may ultimately be evicted or who have an eviction notice, it's critical that they get help now, that they contact that coronavirus hotline. The folks working on that hotline have direct contact with me. They let me know when those cases are available, and they let me know essentially who to expect to have in court. We will often then reach out to those tenants to talk with them about their situation and ensure that they're able to make it to court. If I'm able to take that case and place it with a private attorney before the court hearing, I will do that as well. So we want to be on the front end of that as best as we can. So the more advance notice we have, the better off, the better results we're probably going to be able to get through the tenant assistance project, which ultimately can be significant for these folks who are being evicted. I don't think I have anything else. So thank you very much for giving me the opportunity to speak about the tenant assistance project. And of course, I'm available afterwards for questions.
Okay, thank you so much, Lori, for that great information. And this is a reminder that at the end of this presentation, we will have all our contact information for all of the agencies that are participating currently with this webinar, and in addition to a few more. So thank you. Now we have one last video that we would like to show you of the experience of another individual who's gone through the eviction process. Thank you both.
Finding a house or a place to live is pretty easy. The difficulty is being able to afford it right now, especially during these times with COVID. So many people are lacking the employment, and so much business has been kind of ruined by it. Ultimately, I have been unemployed because of it. So rent is kind of an issue, but proceeding the court cases, I have resources to find rent assistance and assistance with my bills. So I'm just going to be in the process of finding a new job, exploring my hobbies that create a profit, and finding home. I feel like my landlords definitely didn't go in the right direction. They started off with a transfer of ownership from a previous landlord, and from then really weren't very clear on what they wanted to do with us. They wouldn't give us any warning that they were going to kick us out. They weren't going to really give us any big information on what kind of rental agreements we'd be having or where to pay rent. They weren't very good with the communication. They really did their best to kind of try and bully everyone in the buildings. Not only myself, but my neighbors, my roommates, we all could see it. It was one of those situations where my gut feeling knew that what they were doing to me was not the right way of doing it, and they were doing it wrong. Their information could have been wrong. I think their information was wrong. The way they approached it was very wrong. The biggest thing that affected me was their lack of proper communication and decency towards others. So I think it's very fair that we push in a direction to give people facing evictions these days a lot more help than they are given, starting from the beginning process till the end. I definitely could not afford any kind of representation. I was very happy to see that there was a volunteer group here, and ultimately I think I've received one of the best lawyers I could ever see, at least at this very point in time. I'll definitely go back to him anytime I ever need him. I believe that.
What a powerful and impactful video we just saw. And so continue to, if you have any questions, please make sure you put those down in our Facebook, and we will have a time at the end of the presentations. So thank you, Laurel, again, for the great presentation and the information that is well needed for our community. So next we have Jermaine Gosavec and Joe Garcia from the Fair Housing of Nebraska and Iowa. They have some great resources and information. And so next will be Mr. Garcia. Thank you for joining us.
Thank you, Francesca. And once again, welcome everybody. My name is Joe Garcia. I am the program director for the Fair Housing Center of Nebraska and Iowa, and my assistant director, Jermaine Gosovac, is running the PowerPoint for us. Yeah, thank you for having us. At the center, what we do at the center is, well, we're a staff of 6. We anything to do with housing we deal with. We're part of a larger organization called Family Housing Advisory Services. Under the umbrella of Family Housing, there's numerous programs, with the Fair Housing Center being one of the programs. And the difference in my program and the rest of the programs under Family Housing is that our program covers all of Nebraska and all of Iowa. So our mission at the center is to eliminate and prevent housing discrimination. What we do is we answer a lot of landlord-tenant questions. Like I said, I have 6 staff, including myself, and I take calls just as my staff does. And we'll get calls, hey, I've been given a 7-day eviction notice. Do I have to be out in 7 days? Or can I withhold this month's rent until my landlord fixes my leaky faucet? And I tell folks that call us, listen, I'm not here to tell you what to do. I'm here to provide you information. If it is January 15th and you haven't had heat in your apartment, if your furnace hasn't been working for 2 weeks and you don't want to pay January rent, I don't blame you. I don't blame you one bit. But the law does not allow you to do that. There are ways to go about getting that furnace fixed, or to approach that landlord, but the law does not allow a person to withhold the rent. So we do a lot of landlord-tenant counseling. We do a lot of education and outreach, talk to social service agencies, government entities, private landlords, public housing authorities about their duty to follow fair housing and Nebraska and Iowa landlord-tenant law. We investigate discrimination in housing. As Marna said, it's illegal to discriminate based on a person's color, race, color, sex, religion, national origin, disability, or because they have children. Those are the 7 federally protected classes. That's straight across the board, across the nation. Each state can add to it, but they can't diminish from it. For example, in Iowa, sexual orientation and gender identity are protected, which means you cannot treat someone differently or place different terms and conditions based on a person's sexual orientation or gender identity. In Iowa, Nebraska, you still can. I like to say we're a little bit slow here, but eventually we hope to come around. So we investigate allegations of discrimination. We act as advocates on the behalf of our clients. We try to help negotiate a mutual agreement between a landlord and a tenant, so that both parties, can continue to do business together, if you will. And then we have a testing program. And I'm just going to touch on this real quick, only because it ties in to what Lori had mentioned earlier regarding the case that she overheard a landlord and their attorney talk about, well, we really don't want to rent to them because of whatever. The best way to describe testing is like a secret shopper type deal. We train people to come to be testers, and we send them out to the place in question. We give them a profile. We tell them this is who you are, where you work, if you're married, if you're single, when you want to move, why you want to move. And they go out or make a call, and they act as if they're interested in renting that apartment or getting that bank loan or getting that a listing for a house. And in the example of a rental, they ask questions like how much is the rent, deposit, application fee, what utilities are included, things like that. When they're done, they fill out a report form. Within a 48-hour period, I send out a second tester, and with almost the identical profile. They ask the same questions, and when they're done, they fill out a report of how that transaction went. At that point, my test coordinator and myself, we look at both reports to see if one person was treated differently than another. So in tying it into what Lori was saying, it would be interesting to run a test on this landlord to see someone would call saying they're disabled, and see how they're treated, what their state. Maybe they say, we don't have nothing available. Maybe whatever they may say, whatever they say, if you will. And then we would have a second non-disabled tester call and see what they're told. Maybe they're told that, yeah, there is something available. It'd be interesting. That's something that would be testable. And that's what testing is about, is just to measure everyday practices of a housing provider. Now, we are a nonprofit organization. We're not the government. We don't have the authority as the FABs do, as NEOC, LCHR, OHRRD. We partner with them quite a bit, but we don't have that authority to file a complaint or to reach out to them and enforce the Fair Housing Act. So we do testing, we do negotiations and advocacy work. Next slide, please. Some of our advocacy numbers in 2019, we took over 1,100 calls from households. Of those 1,100, 339 of those calls had a potential for a fair housing violation. Of those 339 calls that are cases that we investigated, 84% were on behalf of people with disabilities. That's a huge number. And throughout this training, everyone's saying what big numbers, and this is just another example. And that's just not in Nebraska and Iowa, that's clear across the nation. So we do a lot of work on behalf of individuals with disabilities. We assisted 124 households to retain or obtain suitable housing. And then we assisted 117 folks with disabilities to obtain a reasonable accommodation so they could fully enjoy their housing unit. And then lastly, we recovered over $361,000 in value to our clients, with that being either monetarily, help them terminate a lease early, get their deposit back, have a deposit waived, in different ways that we count that number. So like I said, there's 6 of us. We cover a 2-state area, so we're very, very busy. And there's 2 of my staff, including myself, are bilingual in Spanish. So next slide, please. We've been talking, and that's what my talk here is, my presentation part is focusing on, is a reasonable accommodation. And a Fair Housing Act requires that housing providers make the necessary accommodations for individuals with disabilities. That being said, there's got to be a connection with that request and the disability. There has to be a nexus, if you will. Under the Fair Housing Act, Brad touched base on, is similar to the ADA, is defined as a physical or mental impairment that substantially limits one or more major life activities, such as walking, such as breathing. So when someone gives us a call, we listen to their situation, we do an intake on every call that we do, and then because we got our main funder is HUD, we got to provide demographics of the people we serve. And so we go through a series of questions. How old are you? Any children in the house? And one of the questions we ask, are you or anyone in the house disabled? And probably 85% say no. But then when I read them back under fair housing law, the definition of that disability, oh yeah, my child has asthma, or I suffer from PTSD, or I have anxiety or depression, that type of deal. And they have documentation of that disability. So we, like I said, some of the work of the 117 cases that we assisted individuals getting that reasonable accommodation, some of those examples, and maybe this might strike a chord with those in the audience listening today. examples of a reasonable accommodation that we've done for folks is getting them an assigned parking spot. There are let's say an apartment complex has parking placards, stalls for folks with disabilities, a handicap parking stall. But every time this particular land or tenant needs a handicap parking stall, it's always filled with somebody else. So they would call us, we would approach that landlord on that client's behalf and ask them to have a reserved parking stall specifically for this client. So they would have a placard that would say reserved for apartment number 101. That's an example. Or somebody who has a mobility issue and they currently live on the second floor, and they've got some type of issues with walking, with breathing, and now they can't. It makes it really hard for them to climb to their second story apartment, but they're in the middle of a lease. So we approach that landlord on that client's behalf, ask them to terminate the lease early without incurring an early termination fee. When we approach that landlord, we like I said, we start off with an intake. We have that client sign an authorization waiver that says they give us permission to work on their behalf. We also request if the disability isn't obvious, if it's not visible, we ask that client to provide us with a doctor's statement, maybe saying they have arthritis, severe arthritis, and living on the ground floor is necessary. We get that note from the doctor, the authorization waiver, and then we ask that client, well, when do you want out of your lease? It's up to them to tell us when they want out. When all our ducks in a row, we approach that landlord and say we're requesting a reasonable accommodation for you to let that client, that tenant, out of their lease early without incurring an early termination fee. And here's a documentation of what they suffer from. And oh, by the way, here's a copy of the fair housing law that says you've got to do it. Now, like I mentioned earlier, we're not the government, so that landlord can tell us, and many have, to go pound sand. And that's fine. At that point, we would if that client wishes to pursue it, we would file a fair housing complaint with one of the FAB partners, NEOC, LCHR, Omaha Human Rights and Relations, and file a complaint on that client's behalf with that organization. Great partners, the three FABs that we work with. The biggest difference between us and them is that we can advocate on the behalf of our clients, where the three entities, the three FAPs, are strictly fact-finding neutral agencies, where that we are with our clients throughout the process. We're not their attorney. They definitely tell them we're not their attorney, but we're their representative. So the process can be a little bit overwhelming, but my investigators are with them throughout the entire process. The 117 number that I previously gave on the other slide of getting that reasonable accommodation means 117 cases were negotiated and did not have to be filed with that FAP organization. So that's a big number, and we're very proud of that we came up to a solution with that landlord and that client. Another example of accommodation is adjusting a rent payment. Let's say in most cases, the rent is due on the 1st, but delinquent after the 3rd or 5th, but I don't get my Social Security disability check until the 7th. And therefore, I'm going to incur a late fee with every month because of my check coming in late. We approach that landlord on that client's behalf and ask them, if it wasn't for this person's disability, they would be able to pay their rent on time. Therefore, Mr. Landlord, we're going to ask you to change this specific tenant's due date on their rent to the 8th or the 9th or whatever the case may be. So that's another example. And then another big one is emotional support animals. I'm a landlord. Let's say I'm a landlord and I have a no pets policy. But someone approaches me wanting their emotional support companion dog, and me being Mr. Landlord say, well, no, I can't let you have your dog. Fair housing is about treating everyone equal. If I let you have your dog, then everyone's going to want their dog, want a dog in my building. And so we approach that landlord and say, listen, you know, this isn't a pet. It's an assistive device similar to a person in a wheelchair or a walker. We are requesting you to waive your policy of no pets because of this person's disability. And those are, so that's another example of an accommodation. Another big one that's not listed here is an early termination of a lease because a unit has mold in it. And my child has asthma. We approach here again, we get the documentation note from the pediatrician, approach that landlord, asking them to let the client out of their lease early. Now, and the truth of the matter is why we are pretty successful at getting these reasonable accommodations, getting that landlord to terminate the lease early, because quite frankly, it's a lot easier for a landlord to say, okay, I'll let you out of your lease early because it's a lot cheaper than me to make the repairs, because once I let you out, I can bring someone else right in behind you and rent that apartment. So that's the unfortunate truth. That's maybe why we're successful at getting that lease terminated early. But if that other tenant that rents that apartment calls us, we'll do the exact same thing for them. If your disability is not, if your disability or the need requested accommodation is not really apparent, we ask that here again, that written documentation from that physician or that therapist or that social worker, anyone that knows firsthand and has been and diagnosed that person with that asthma or depression or allergy, whatever the case may be. Next slide, please. Reasonable accommodations related to COVID. As we're all in it, we've all experienced it. We see the news every night. People with disabilities run a higher risk of contracting. People with underlying health issues are at a higher risk of contracting COVID. A forced relocation, either eviction or a non-renewal of lease. We've done a couple of cases recently where, and Lori, it sounds she got an RA by extending that eviction more time for that tenant of hers yesterday, and that's what we've done. We were approached by a woman who was given a non-renewal, not an eviction. The housing provider decided not to renew their lease, but she also had a child with underlying health issue, and to go out and look and finding another place and being out when we were here in Nebraska. Obviously, we're luckier, much luckier than like say New York or wherever that number's going up. But nonetheless, back in May and March and April, when it was really, really bad locally, it was just tough to go out and look. Everyone was afraid and everyone was being told to stay home. Nonetheless, they approached us, can we get a couple more months or at least another month to see where we go with this pandemic. I think this was Jermaine's case. She was able to approach that landlord and let's say, listen, because of the child's disability under fair housing law, because of the current pandemic we're suffering, we're asking you, Mr. Landlord, to allow the tenants to reside there another couple months so that they can have time to find a place and safely find a place and relocate. So we were successful in a couple of those type deals. Same thing with elderly. We all hear that the elderly are highly susceptible to COVID. And I just took a call today that an elderly gentleman's has to be out, although it is the 15th, he's got to be out in 15 days. Hard place, tough time to find a place. And then here again, he's highly susceptible. So it sounds like we're going to be doing a reasonable accommodation request to extend that elderly gentleman's lease. So if you receive a notice of termination and you believe you're highly susceptible and even outside of COVID, you need a ground floor unit, but because you have mobility issues, it would take you a little bit long, a person with mobility issues a little longer time because you need a specific type of unit. That's something that we can request the landlord if you need more time. Now, we can't negotiate another year for you, but at least another month, maybe 2 months for you to find a specific unit that you may need. It's possible to request a reasonable accommodation after your landlord has filed an eviction. I think that's what Lori was speaking about yesterday with the client she assisted. The Fair Housing Center helps people with disabilities avoid eviction by, like I said, requesting additional time, and a housing provider's failure to grant a reasonable accommodation may result in a fair housing complaint filed. That's where we bring in our partners, NEOC, OHRRD, and LCHR. Next, please. So some tips for reasonable accommodations. You need to be proactive. Don't delay until the last minute. We get that we're going to need, if the disability isn't obvious, we need verification of that disability, and that can, like I said, it could come from a doctor, a social service agency worker, even a priest, a clergy person, social service agent, social service agent. I don't know if that's not the right word. So we need that form of verification. Now, we are hearing more about these people with emotional support animals who are paying $50 for a note to verify that your animal is an emotional support animal. Those are becoming more prevalent. If you've got to pay for a note, then you can pretty much count that it's not legit, and that housing provider can turn it down. That note has to come from a therapist or someone who specifically knows the condition firsthand. And if you have any questions about should I pay for this or not, by all means, you can give us a call. Reasonable accommodation should be made in writing. Although it doesn't have to be, but documentation rides rules in anything we do. So we would prefer that you do it and keep a copy for yourself. And then we document, we approach that landlord, and if that accommodation is granted, we ask that landlord housing provider to provide us with an email or something in writing that says you're allowing to let this person out of their lease, or you're allowing to allow that emotional support animal and not charge a pet rent or pet fee. So we always provide that. We ask for that documentation so we can give it to our clients and they have it for their files. Just like the rest of everybody else, all of our services are free. We don't charge. Like I said, our major funder is HUD, and we work with contracts with our 3 FAP partners, not just in Nebraska, but throughout Iowa. If you have any questions, that's our contact number. We also have a toll-free number there. Give us a call. Like I said, we won't tell you. And I also provide technical assistance to landlords. I tell them the same thing. I'm not going to tell you how to run your business. I will tell you what your options are, what you're allowed to, what you're not allowed to under Nebraska and landlord tenant state law. But either way, give us a call. If you may need our services, or you know someone who could use our services, please don't hesitate to reach out to us. Thank you.
Okay, Great, Joe. This was great information. Thank you so much for being with us today and giving us, kind of a breakdown of what your agency does and how everybody, each of the agencies that were with us today collaborate together. This was great. And just keep in mind that, and I'm going to reiterate a little bit of what everybody said, the information that you were given, the agencies that are working together to bring this assistance to people, whether you have disabilities or not, whether you're facing eviction or not, it is free. There is no charge for it. At the end of this presentation, there will be the names and phone numbers of each of the agencies and a couple of more of the resources for you to contact us. Know that the Lincoln Commission on Human Rights does have a tool in place on our website to report any discrimination complaints. And for that, you can go to lincoln.ne.gov. And so any questions? We have not had questions, but we have had great comments on Facebook, and we do appreciate everyone who tuned in to be with us today. So with that, thank you to all of our participants. And I did see a brief video of a gentleman by the name of Matt who is homeless, and he did an excellent job of summing it up for us. And I'm going to quote him, and he did say, "Homelessness is not a problem. It is a human problem. So we all have due diligence, and it's our responsibility to try to figure out how we can help those in our community." And so thank you again to all of our speakers for their taking time from their busy schedules to joining us today. With this, it concludes our webinar today. And remember, we all have rights.